Welcome, everyone. I'm Abigail Seidner. I'm the Executive Director of the Birnbaum Women's Leadership Network here at NYU School of Law. We're so excited that you've joined us tonight to discuss Justice, Justice, Thou Shalt Pursue, a life's work fighting for a more perfect union, written by Professor Amanda Tyler, together with the late Supreme Court Justice Ruth Bader Ginsburg. The Birnbaum Women's Leadership Network at NYU School of Law works to remedy gender inequities in the legal profession through innovative leadership training and conversations like these. We're so grateful to Professor Tyler and to Dean Morrison for joining us tonight for this conversation. Also wanted to thank our co-sponsors tonight, the NYU Office of Global Inclusion, Diversity, and Strategic Innovation, and the John Bradamus Center. Before I turn it over to Birnbaum Women's Leadership Network Faculty Director, Professor Melissa Murray, for our introductions, a few logistics. First, if you haven't read Professor Tyler and Justice Ginsburg's book yet, you can find a link to purchase the book on our website, which we'll put in the chat. And we will have time for questions at the end, so please submit your questions via the Q&A box on your screen, and we'll get to as many as we can. Live captioning is available for this event, so if you wish to access the captions, please click closed captioning button on your screen. And now I will turn it over to our faculty director, Professor Melissa Murray.
Hello, everyone. Thanks so much for joining us today. We are so excited for this conversation. Before we start, I should say that one of the singular joys of being the faculty director of the Birnbaum Women's Leadership Network is the opportunity to highlight the tremendous work of so many amazing women lawyers. And tonight's event is no exception. I am truly, truly delighted that we are able to sponsor this terrific conversation with two really fantastic colleagues of mine. The first colleague that I'd like to introduce is none other than NYU's Dean Trevor Morrison. In addition to being the Dean and Eric M. and Lori B. Roth Professor of Law here at NYU, he's been a stalwart supporter of the Birnbaum Women's Leadership Network, and we could not ask for a more enthusiastic participant for all of our endeavors. So we're excited to have him here today. Dean Morrison's research and teaching interests are in constitutional law, federal courts, and the law of the executive branch. He was previously a law clerk to Judge Betty Binns Fletcher on the Ninth Circuit and Judge Ruth Bader Ginsburg at the US Supreme Court. Among other positions, he's also worked as an attorney advisor in the Department of Justice's Office of Legal Counsel and as an associate at Wilmer, Cutler, and Pickering, and as associate counsel to President Barack Obama in 2009. He is an honors graduate of the University of British Columbia and holds a JD from Columbia Law School. Our conversation today is between Dean Morrison and Professor Amanda Tyler, who is my former colleague at UC Berkeley. Professor Tyler is the Shannon Cecil Turner Professor of Law at Berkeley, where her research and teaching interests include the Supreme Court, federal courts, constitutional law, legal history, civil procedure, and statutory interpretation. She is the co-author with the Honorable Ruth Bader Ginsburg of Justice, Justice, Thou Shalt Pursue, a life's work fighting for a more perfect union, which was released this week by the University of California Press. Prior to joining the Berkeley faculty in 2012, Professor Tyler served on the faculty of George Washington University Law School. She holds a degree in public policy with honors and distinction from Stanford University and a JD magna cum laude from Harvard Law School. Prior to entering the academy, she was a clerk for the Honorable Guido Calabresi on the Second Circuit and also for the Honorable Ruth Bader Ginsburg at the United States Supreme Court. Please join me in welcoming Dean Morrison and Professor Tyler. Thank you.
Thank you, Melissa. Good evening, Professor Tyler. I'm going to call you Amanda, and I hope you'll call me Trevor.
Sounds good.
Okay. Thank you so much for joining us for this event. And on behalf of really everyone, thank you for working with the Justice to put together this terrific book, which I've really enjoyed reading over the last several days. So there's a lot that we can talk about this evening. I should say to the audience joining us, we're going to reserve time for questions from all of you. So if you use the Q&A button there on the bottom margin and pose a question, we'll try to get to as many as we can starting at about 6:15. But between now and then, Amanda and I will go back and forth over a number of topics. Why don't we start, Amanda, with telling us about the genesis of this book? How did it come to be? What were the goals in putting it together with the Justice?
Yeah, so I'm happy to speak to that. But I do want to say thank you to you and to Melissa and to the Center for hosting this. It's a real privilege to be with all of you. And it's a special privilege to be in conversation with you, Trevor. We have a shared mutual affection for our former boss, which is profound. I had the great privilege of working with her on this project as a result of a visit that she made to UC Berkeley in the fall of 2019. The visit itself was actually postponed. She was supposed to come originally in January of that year, but because of the discovery of lung cancer in December of 2018, we had to postpone that. And she was actually resistant to postponing it, in part because the genesis of the visit was an event to honor Herma Hill Kay. Now, Herma Hill Kay was a friend of the Justices going back some 50 years. And the two of them, together with a third co-author, had written the first ever casebook on sex discrimination in the law. And they actually had done this at the urging of their students at Rutgers Law School and at Berkeley Law. And effectively, in writing that casebook together, they had founded the field of sex discrimination in the law, which then, of course, launched the Justice's advocacy career. But that was a really special friendship. And that was why she was coming to Berkeley. That's also part of the story of how the book project then unfolded, because when the Justice eventually did come and we sat down for a conversation about her life and career at an event that was to honor Herma, we knew at the time that the University of California Press was considering publication of Herma's final work, which is called Paving the Way, America's First Women Law Professors. As the title suggests, it's a preservation and a chronicling of the story of the first women law professors in this country. And that work was enormously important to Justice Ginsburg. She had written the introduction for the book in 2015, and the book in 2019 still was not published. So she got the idea that if we took our conversation and we turned it into a book, maybe the University of California Press would liken to the idea of publishing the books alongside one another. And to our great delight, they very much embraced the idea. And I'm just so thrilled as I sit with you here to be able to say that the two books are releasing alongside one another this spring. And I should add a special note that Herma's book begins with an introduction by Ruth Bader Ginsburg and concludes with an afterword by none other than Melissa Murray. So these are two inextricably linked projects, and it gives me great joy that Herma and the Justice are still writing together and still in conversation with one another today.
That's a great story, and it seems just like the Justice to think about how to strategize prompting action that hadn't quite happened yet, even in the midst of a parallel project. That's terrific. So some of our audience here tonight may already have seen the book or ordered it at least, but probably most haven't yet had a chance to read it. Do you want to tell us a little bit about the components of it? And in particular, when we get to talking about the portion that introduces readers to certain cases and opinions of the Justice, how those selections came to be made?
Of course. So the book is anchored around the visit to Berkeley, in which I interviewed her, and I know you have had the occasion to do this as well, about her life and her career. And what I love about that is that in the lead up to the event, we had had a lengthy back and forth about what we would discuss. And predominantly, you're hearing her tell her life story in her own words. Then what we did was we sat down and we had this lengthy back and forth about what sort of materials we could bring in that would complement the arc of her life and career as she laid it out in that conversation. And there are some really fun aspects to it. So for example, a lot has been made of that first case that she litigated that sort of launched her advocacy career, the Moritz case, which was a tax case that came to her attention, as you well know, and many who've seen the movie On the Basis of Sex now know, from her husband, Marty, the great tax lawyer. And what was so special about that case, of course, is that they litigated it together. And then, of course, Marty sort of stepped to the side and said, you take it from here. But they won that case, and it was a huge win. And she talks a lot about that in our conversation, and about how that case itself wound up lending itself to laying out a roadmap for the work that was to be done in the 70s, both in the courtroom and before legislatures, in terms of lobbying for legislative change. But no one had ever published the brief that the two of them wrote together and filed in that case. So that's one of the things that's in the book. And what I love about it is that it really lays out for you the vision that she had way back in the early 1970s of the work that lay ahead and what her ambitions were. And her ambitions, of course, were included, I should say, having gender discrimination treated like race discrimination in terms of the level of scrutiny that was given to such distinctions. She never quite fully succeeded in that regard, but she certainly made up quite a lot of the distance between where gender discrimination was at the start of the 70s and where it is now. Then I asked her, well, do you have favorite oral arguments? And she picked her favorite oral arguments, and we've included those transcripts with some annotations in the book. And then we sat down and said, okay, let's talk about this incredible career. You know, she wrote over 1,000 opinions as a judge over a 40-year career, 480 some as a Supreme Court justice. It's hard, I imagine. I mean, I can't fully imagine what it's like to look back on that, but I imagine it was very hard for her to pick her favorites. And indeed, she says in the book that it's a bit like asking her to pick a favorite grandchild. But she eventually, through a lengthy back and forth, settled on four of her opinions. And those are the ones she said that if someone reads nothing else, she hopes that they'll read those from her time on the court. And I'm sure we'll talk more about them, but it is interesting, I guess I would say, that most of them are dissents. And I think that there was a method to that. There was a reason for that. She really wanted to inspire people to keep doing the work, as it were. And then finally in the book, we have some of her final speeches. And what's so special about those is that they haven't been published before. And they're a range of speeches that have her talking about being a child and who her role models were, particularly among Jewish women. You have her talking about the influences on how she thought about being an advocate and her strategy, but also how she thought about judging. And then a magnificent final piece of the book is a beautiful speech that she gave at a naturalization ceremony, where she talks about her family, and she talks about how proud she is to be the child and grandchild of immigrants, and how important it was to her, and how proud she was again of the fact that as a child of an immigrant, she sat on the Supreme Court. And that, as she says, is really a testament to the promise of this country and the potential of this country.
I'm so glad that those were included. We clerks get some greater glimpse than others into the justice as lecturer and speech deliverer, or as orator, because we may end up helping her with some of those speeches that she delivers in the year that we're with her. But I think you're right. I mean, they're typically not published more broadly. And one hears lots of stories, I'm sure you have over the years, from folks who were fortunate enough to be in the room when she was delivering one of these, about the care and thought that she put into every major speech that she delivered. And so through this book, you know, many, many more people are going to have the benefit of being able to read these. So I'm really glad that you did that. I was also really struck by the decision with the 4 opinions that the justice selected, that the book includes not just the opinion, but the so-called bench statement. So the statement that a justice would always deliver in a majority, might only sometimes deliver if in dissent, providing a kind of summary statement. And those two, as we know well as former clerks, were things that she didn't just tear off at the last minute, but that were poured over as their own standalone documents. And so we have those as well for each, which was really terrific to include. Was it clear from the beginning that those would be included, or was that your idea to suggest it to the justice, or hers, or how did that come about?
I can't remember whose idea it was, but it made sense, because the hope from the beginning of the book was that it would reach a general audience. And the truth is, we know some people might not want to read a full opinion.
Right.
I'm happy to report a lot of people who are non-lawyers are telling me that they're loving reading these opinions, that they had no idea how interesting they would be and how well written they would be. Of course, those of us who are familiar with her jurisprudence, this is not a surprise to us. Yep. But I thought, and she thought, including the bench statements, would at least give the general reader a rough summary of what the case was about and why she was dissenting. But I also, as you say, it's noteworthy that she did read bench statements, particularly in the dissents. And I think, again, there she's underscoring how strongly she felt about the position she staked out, how wrong she thought the majority was, and how, as you know, she often said of her dissents, they're written for the future. And yeah. So it's no accident that she included a number of dissents here, because she was writing for the future. She was writing for, you know, the kid who picks up this book in 10 years and sees, my God, we still have a lot of work to do on voting rights, or even someone who picks it up today. And you're right. I mean, you can speak to this as much as I can in terms of the care with which she took with everything she did. She was so meticulous. I may have told you that in the last summer when we were working on this book, I would send her pages, and I'm sure you had this experience where sometimes the assistants would print off your work. Well, they printed off the pages for her, but they also printed off my cover emails. And we can talk about how meticulous she was. I will just share, to my great embarrassment, that not only did the pages for the book come back edited, but my emails did as well.
It couldn't be otherwise. I think once the editing pen is out, any document is subject to it. That's funny and familiar in my own experience with the justice, let me say, too. So tell us about the four cases. As you say, 3 dissents and 1 majority. And the majority is, I think it's fair to say, the majority opinion for which she is best known in the VMI case, which many of our audience members may know, but that's in many ways a culmination of her career around advocacy for gender equality, in that it's when the court solidly entrenches the idea that state action discriminating on the basis of gender should receive formally heightened judicial scrutiny, and in application of that scrutiny, the court majority, in a majority opinion written by Justice Ginsburg, strikes down the male-only admissions policy at Virginia Military Institute. I do think that's, in the space of gender equality, the opinion we most associate with the justice, probably, though certainly not her only. Tell us about the dissenting opinions.
Yeah, so the dissenting opinions, you know, we have 2 that are gender-based, and we have one that has to do with race and voting rights. And these are areas about which she felt great passion. We already knew that about gender discrimination, but what I like about the inclusion of her great Shelby County dissent, and I'm biased, but I think it's a dissent for the ages, is that it shows that these are concerns more broadly that animated her jurisprudence across different areas. It wasn't just about equal opportunity for women. It was about equal opportunity for everyone to participate in society, to have a voice in society, and to be able to have the full range of opportunities available to others. That's what she was about. And the VMI opinion very beautifully encapsulates that. There are passages in there that I think you can pull out and say, this is what she was about. So for example, there's a passage in VMI where she talks about and celebrates the fact that our Constitution over time has evolved to bring under the umbrella of its protections groups that were once excluded. That's a great thing that we should celebrate, she says. You know, there are other passages in VMI where she talks about how every individual needs to have the opportunity to achieve their full human potential. That is also what she was about. And again, that wasn't just limited to gender. And that's why I love that Shelby County is in there. I also just love that dissent because it's so powerful. It's so correct. Again, I'm biased, but it's also beautifully written. So that's one that I was so pleased she wanted to include. And she was very proud of that dissent. And she really does hope that dissent winds up having traction in the future. Then there's Ledbetter, about which she's so proud because she was very angry to be in dissent in that case, a case involving ongoing pay discrimination in the workforce, directed at a woman in that case, where the majority really cuts off the ability to complain about the compounding discrimination that's happening over time. And borrowing a tactic from the 70s, she includes as the last part of her dissent, well, you know, this is a statute that we're talking about, and ultimately it's Congress's right to change a statute. So Congress can correct what the majority has done here. And of course, Congress did that. And I made reference to the 70s. You know, in the 70s, a big issue that she was involved in litigating and writing about and pushing for legislation in was pregnancy discrimination. And the Supreme Court, not once, but twice held that pregnancy discrimination is not gender discrimination, including under Title VII. And she wrote with a fellow lawyer at the ACLU, wrote an op-ed for the New York Times, the last portion of which is Congress can fix this. And Congress did with the Pregnancy Discrimination Act. So this was something she had done in the past. And then the final dissent is in Hobby Lobby, and it's a reproductive rights case, a topic about which she was very passionate, but she also viewed it as a gender rights case. And she talks there about how if women don't have control over their reproductive freedom, they're always going to be held back. They're not going to be able to control their own destinies. And again, that comes back to those dominant themes about allowing everybody to sort of have control of their destiny and be able to achieve their full human potential.
I think they're just terrific choices there. It's an embarrassment of riches. One could have picked 4 others at least, or many, many others that were great candidates too, but these are terrific. I agree with you. Shelby County is a dissent for the ages. And that line about concluding that the Voting Rights Act's preclearance protections are no longer necessary because of the strides that have already been made with respect to race is like an umbrella rainstorm because you weren't getting wet under the umbrella is, my paraphrase is less good than the actual text, but it's a great line. And I think in one sentence delivers the message about the problem with the majority reasoning. And I agree about the majority in VMI as well. The passage when I teach that every year that sticks with me is and really the message that's throughout her opinion is that part of the point of ensuring equal protection is to preserve the freedom of people to act contrary to what the majority of members of their gender or whatever the classification is might want to pursue in their own lives. So the fact that hardly any women were likely to seek admission to VMI was neither here nor there. It was precisely for individual people to be able to make decisions about their lives, even contrary to stereotypical expectations. It's such an important message, I think, to convey. It's interesting that the Ledbetter dissent, I think, which is also an incredibly powerful dissent, as you suggest, was functioning slightly differently. That seems less to have been written for the ages than for, the following morning and for Congress to get its act together, as it did in early 2009. And it was the first substantive piece of legislation, the amendment to the statute signed by President Obama. What did you think in your conversations with the justice, other than cases like that, where she had a specific, I want to call out the institution in whose court the ball now sits? We talk about writing for the future. How do you think she thought about that? Was it a matter of trying to affect the thinking of law students who might one day become judges and justices themselves? Was it speaking even beyond the lawyerly public, to the public generally? Was it speaking to her brethren on the court who might outlast her on the court? What do you think?
I think all of the above. I mean, I'd be interested to hear what you think. As you've studied her and worked with her, same as I have, I think she really wanted to speak to a broad audience. And I think that's one of the reasons why she so enjoyed being the notorious RBG, is because it put her, and again, I'd be curious to hear what you think, but it put her in conversation with a bigger audience. And when I clerked for her, I'm sure the same for you, she was so meticulous. Part of that was that she wanted opinions that were accessible, that someone could pick up and read and understand, whether they were a trained lawyer or not. And I think that was part of what was an exciting aspect of doing the book for her, was that hopefully people would do that now with some of these opinions. And so I think it is partly for the people. It was partly for Congress in certain circumstances. Definitely, she was, and I'm sure you could say the same, she did not like to lose. And so when she was writing a dissent in real time, certainly it was for her colleagues to try and see if she could pull a vote. And she rarely, if ever, did. But she was darn, if she was going to back down, she was going to try till the end. I mean, she talks about going back and forth, for example, with Justice Scalia in VMI. And I think she had some hope that eventually she might convince him. It was hopeless, of course. He winds up being the only dissenter, but she would never give up. And I definitely think she was writing for law students, because being as forward-looking as she was, being as hopeful and optimistic as she always was. I mean, this was a huge part of how she thought about the world. She was a fierce optimist. Yes, we would see the setbacks, but we'll get there. I mean, that's the kind of way that she thought about. You just put your nose down and you keep doing the work. And so I think that those dissents are also speaking to the next generation of lawyers to say, don't give up. Let's keep waging these fights.
I really agree with that. I think she was an incurable optimist, which is not something that necessarily comes through just on the written page of these dissents, right? Because she's not sparing, she's never gratuitous in the criticism of the majority, but she's not going to pull punches, that's for sure. And one doesn't necessarily associate that with a kind of unceasing optimism. But I agree with you that she had that too. And that meant that she wanted to engage with her colleagues on the bench who were most unlikely to agree with her, as well as the ones who were most likely to agree. And I agree too that there was sort of perpetually this hope that folks would come to see things as she did. And I think similarly, I'm sure you experienced this. She wasn't a closed-minded person herself. She would rethink premises, when presented with new arguments. I tell my students that one of the most important lessons I took away from clerking with her was that one should always think about the argument on the other side of an issue in the best possible light, to present it in the strongest possible terms, maybe even better than the advocates on that side had presented it in, and only then show why it's wrong, as opposed to caricaturing an argument or kind of setting up a straw man or something. I remember, worrying that any draft I would write for her might present arguments on the other side as only straw men, and that would get me in trouble. But I think that goes along with the optimism, actually. I think there's a presumption of good faith that she seemed to carry with her.
I think that's right. I didn't mean to interrupt, but I really do think that's right. And I saw the same thing as her clerk, that she really modeled how important it was to take seriously the arguments on the other side and confront them head on. Right. And, that might make you rethink things in some respects. And I saw that happen in the year that I was with her, never rethinking something dramatically, but enough to sort of give pause and reflect. And I think that harkens back to her testimony when she was nominated to the court. She quoted the spirit of liberty. And she said, the spirit of liberty is never completely certain that it's right. And it has to always listen to the other side without bias. And I think she tried to do that as a judge. And that was a really important lesson for us to be able to see.
Yeah, I agree with that. That great line from Learned Hand, the spirit of liberty is the spirit that is never too sure that it's right. That kind of humility. The idea that it's not inconsistent for that humility to go along with a deep conviction to principle, which she certainly held.
Absolutely.
How have you, in particular, since the justice's passing, and I do want us to talk a bit about your really wonderful afterword in the book, which, as you say, should never been written, was never meant to have been written, but that you did write after her passing. And it's a beautiful conclusion to the book, and I want to thank you for writing it. How have you been thinking about her in these 6 months and a few days since she passed?
That was the hardest thing I've ever had to write, without any question. When she passed away, we had turned in the manuscript 3 weeks before her death. And the press immediately wrote me and said, you know, one, we're sorry, and two, we'd really like to get this book out, and there's going to need to be an afterword now. And I recognized that that was something that would need to be included. It would have to be contextualized because it was, you know, it's her book, and to have it come out posthumously, you need to explain the context of that. But sitting down, it was incredibly difficult to write. The first line of the afterword, as you say, is this part of the book wasn't supposed to exist. And I think even now, 6 months later, I still feel the same. I can't tell you how much I wish she were here, and instead of me having this conversation with you, maybe you all would let me come along for fun.
Absolutely.
But I would give anything for that to be the case. You have the same affection for her and the same bond with her that I did. And, you know, for those of us who were so lucky to have our lives so dramatically changed by the privilege and honor of clerking for her, this has been really difficult to process. And people who didn't even know her are having trouble still processing it. So I guess I take comfort in that. What I will say about this particular moment and having the book come out is I am really glad that it's leading to a new round of discussion about her legacy. And my hope is that it will lead people again to celebrate the great accomplishments of her life, and that it will keep that conversation going, because she's a really inspiring figure on many, many levels. I mean, those of us who clerked for her saw how resilient and tough she was firsthand. She had cancer for the first time the year I clerked for her, and it did not slow her down at all. I mean, it was just incredible. And I saw that same resilience, and I know you did, in the last year of her life. You and I, the last time I saw her was with you. The two of us had dinner with her. Was that the last time you saw her as well?
It was, yeah. I was just thinking about that.
And, you know, we saw how resilient she was and how much she was fighting to try to hang on, and she was still doing the work. So she's just this monumentally inspiring figure. And I hope that comes through in the book. And I hope that her example more generally, that it just continues to resonate with people, and that people pick up and keep doing the work.
Yeah, I think it does. I think that does come through in the book. It's one of the magnificent aspects of it. So in the classroom, you've been one of the nation's leading public law scholars and teachers for many years now. Are there specific things? I mean, this is a hard, even as I ask it, it's a hard question to answer, because I think the influence of such a person on all of us is pervasive. But are there aspects of lessons that you hope to impart to your students that you trace to things you learned from the Justice?
There's so many. I'm sure that you could say the same, and I'd love to hear what your answer is to your question. I think the two biggest lessons in terms of, I'll share two lessons about the law and one about life more generally that is connected to how I interact with my students. But on the law, you know, she taught me, and I try to teach this to my students, to think about the law as a force for good, to think more generally about how the law can open up opportunities for people. And then on the law also, and this is really, I think, a very powerful part of her legacy, she taught me how to think about, and how important it was to think about, how the law affects the lives of real people. And so when I'm teaching cases, for example, I taught a Fourth Amendment case this week in the Supreme Court seminar that I teach. It's a case that's pending before the court. And the case involves the question whether, if somebody runs a stop sign or honks their horn too loud, as the facts are in that case, and the police think that there's been a misdemeanor and the person winds up going into their home, can the police follow them into their home? And I said to my students, okay, let's not just think about how this plays out in this case. Let's think about how this could play out in the lives of a broad spectrum of American society. And when you do that, you start to realize this is very problematic. And that way of thinking is something that she taught me, that you have to not think about the theoretical aspects of a case that goes to the Supreme Court alone, but how the trickle-down effects will be. And we had a Fourth Amendment case that's very similar the year I clerked, called Wardlow, in which the question was, whether fleeing from an officer is suspicious behavior. And I'm very proud she was in dissent in that case, because I think she recognized that for a lot of communities, the police are not friendly and fleeing is not an irrational reaction. So she taught me that, and I try to teach that to my students. The other thing that she taught me more generally, among so many other things, was how important it is to use your position to help others and to help advance the careers of others. So I surely, like you, benefited from her supporting my various endeavors. After serving as her clerk, she picked up the phone on occasion to help me get a job. And I am so grateful for that. I know that it was a game changer in my life on multiple occasions. And I think about that when I'm thinking about my students and how can I help them. I'm not Ruth Bader Ginsburg, let's be very clear about that, but I'm a professor at a top law school. And if I pick up the phone to help someone get a clerkship, maybe that will help. And so I think about her example and I try to pay it forward with my students.
That's wonderful. Yeah.
But I want to hear your answer to that question.
Well, I mean, none better than yours. But I think both of those lessons really resonate with me as well. You know, it's interesting for someone, her, you know, initial passion and still continuing throughout her career in the law was civil procedure, which may not be the place that one immediately runs to think about the sort of human drama. But I think that her brilliance in that space and elsewhere in the law was always understanding what was actually at stake, even if the area of doctrine had a way of expressing itself in a more dry and impersonal way. And that's a very important thing. It's easy for the study of law for our students to feel like it has an abstracting quality to it and to be taking away from the lives of the human beings that are drawn up voluntarily or involuntarily into the law. I agree with you. I think that was always something, you can see that in her opinions too, making sure that there's a clear understanding of what's actually at stake. And I agree too, that by her example, she showed what it means to be a supportive mentor and to help to use one's own position to advance the careers and lives of others. And she certainly did that for me. I was on the law teaching market when I was clerking for the justice, which in retrospect was not the wisest decision in the world, but the justice was okay with it as long as, the day job took precedence, and it certainly did. And I'm certain that but for the phone call that she placed to the appointments committee up at Cornell, I never would have been hired there for my first teaching job. And that was just the beginning of many supportive moments. And as you say, neither of us is quite in the position to exert the influence that she did globally or individually, but the model is one that I think we're all committed to trying to replicate and continue. For me also, this idea of trying to approach even deep disagreement in matters of the utmost importance with a kind of presumption of good faith, that you'll engage with those with whom you disagree on the basis of that presumption. It's something that's very hard to do. And I'm sure I don't always succeed in doing it, but I think of her as I struggle to do it because I saw her do it. And it wasn't because she didn't feel very, very strongly of the rightness of her own views, but it was, I think, connected to this optimism that you referred to, that progress could be made over time. I remember the year I was clerking for her, another volume of this book could have involved opinions not written by Justice Ginsburg, but where the opinion owed a lot to Justice Ginsburg. And an example of that is the majority opinion in a case called the Hibbs, which was decided the year that I clerked, which is about the Family and Medical Leave Act and a challenge to whether Congress had the authority under the 14th Amendment, Congress's authority to enforce the Equal Protection Clause, whether this was a valid exercise of that power. And Chief Justice Rehnquist wrote the majority opinion, and it expressed this very sort of facts on the ground based understanding of what actually was at stake in matters of equal treatment of men and women workers in the workplace. What the Family and Medical Leave Act, the provision there was doing, as you know, was guaranteeing 12 weeks of family leave to everyone working for a covered employer, regardless of gender. And the idea here was the hope was that more male employees would take this leave, which would over time cause employers not to view their female employees as likely more expensive or not worth the training because they were just going to take family leave at some point. And on that theory, the court upholds this as a permissible exercise of legislative power under the 14th Amendment. I can remember when the justice came back from conference and when the vote for how the case was going to go was first expressed. And she had this look in her eye that was clearly one of pride, that she was proud of her colleague, Chief Justice Rehnquist, that he had reached this conclusion. And I think that was the result of the influence of Ruth Bader Ginsburg on William Rehnquist over the course of the years that they had worked together. Not only that, I mean, of course, he came to his own conclusion. But that too, I think of the possibility of change. I think it was the last time she came to NYU to speak. She was being engaged in dialogue with our colleague Kenji Yoshino, and he asked her about her views on the incomplete nature of the quest for justice and for equality with respect to race and gender and so many other considerations. And of course, she underscored the unfinished nature of that struggle, but she also underscored just how much progress had been made since the time when she was a student. And that's something you'd hear the justice emphasize too. And it seemed to me she thought it was important to tell our students that, to give them a sense of the possibility of further change. That things had come a long way since she was a student. And so there's every reason to believe they could go a long way again going forward. I don't know if you ever heard her articulate that view, but.
Yeah, I mean, I think this was a big part of how she thought about the world and the work. And it's the benefit of talking with somebody in their 80s that they've seen a lot of life. And she had seen dramatic changes on many planes. And I think that is what fueled her optimism, is this belief that, look at all the progress we've made. No, we haven't gone as far as we need to, but we're pointed in the right direction. And if we do the work, we'll get there. And for her, sometimes, it took a long time. You made reference to VMI. That's the culmination of a case that she litigated and lost in the 70s. She litigated the Vorchheimer case, which was a challenge to separate high schools for gifted students, if you like that term. High achieving students, maybe is a better term. And there was a boys' high school and there was a girls' high school. Surprise, surprise. In the 1970s, the boys' high school had better facilities, better classes, more math and science. And a girl said, I want to go to that school. And she tried to bring a class action. And the justice got involved at the Supreme Court. Local counsel brought her and the ACLU in, and she wrote the opening brief to the court. But then there was a difference of opinion between local counsel and the ACLU. It's a great article about this that spells out, they had very different views about how to litigate this case. And local counsel sort of pushed the ACLU and the justice off the case, wrote the reply brief herself, argued the case herself. We could certainly ask, gee, what if Ruth Bader Ginsburg had done that argument? What if she had written the reply brief? The case goes 4-4 because Rehnquist is actually injured and he can't hear the case. And of course, when a case goes 4-4, the lower court decision is affirmed. They're upholding the separate high schools. When VMI comes back in front of her, now she's on the Supreme Court. It's 20 years later, and she writes for the court striking it down. And that, I think, is a really emblematic statement about why she was optimistic, or a good indication of why she was optimistic, because yes, it took 20 years, but we got there. We got the holding from the Supreme Court that the state, as you say, can't sponsor unequal opportunities for men and women. Yes, I think she would have preferred, no doubt, to get there in the 1970s.
I'm sure.
But we got there.
Yeah. I think that's exactly right. Exactly right. What advice have you heard the justice? This is sort of just a further extension of what we've been talking about. What advice have you heard her give to law students today? Other than, we can get there, it might take a while. But I think a high fraction of the folks with us tonight are law students now. And so virtually all of them wouldn't have had the opportunity to meet the justice, and probably not the opportunity to hear from her directly. So if she were here with you tonight, and I'm sure we would have invited both of you, what advice do you suppose she might be giving to law students today?
Let me just say at the outset how much I would have enjoyed that if she were here with us and the three of us could have been in conversation. She said several things to my students over the years. She came a few times to talk with my students. One of the things she said was, do something outside of yourself, which is to say, here you are at this great law school and you have these extraordinary talents. Use them as a force for good. Think about how you can use your talents to make the world a better place. Don't just chase a big paycheck, she said to my students. And her life is emblematic of that. From the beginning, it was a life of service. It was a life of trying to use her talents to make a contribution. I think that's her story of resilience, is that every roadblock under the sun from very early in her life was thrown in her way, but she was just so determined to contribute, and that just kept propelling her forward. So that's one thing she said to my students. Another thing she said, and this is in the book, I asked her, how does it make you feel when you were one of 9 in a law school class and you come to a law school, in our case, Berkeley, and 60% of our students are women? And she said, overjoyed, just absolutely overjoyed that women now are accepted at the bar and are here en masse. So I think she was very excited about the direction of our profession. Again, still there's work to be done, but she was really, really excited about that. And then the other thing I asked her in this most recent conversation that's in the book is, what advice do you have for my students? I get these questions all the time from students, male and female. How do you balance the different parts of your life, and particularly family and work? And so I asked her that, and she said, my number one piece of advice is choose a partner who thinks that your work is as important as theirs is, because that's what she did. And, you know, and her partner, Marty, who you got to know too. I mean, just watching that marriage, it was a love affair for the ages, and it was a match of equals. They were each other's biggest supporters and fans. He was, as you've said, a tremendously successful, a great lawyer, probably the greatest tax lawyer of his generation in his own right. And yet they shared this mutual deep affection, and they cheered for each other. He is responsible in large measure for her getting on the Supreme Court because he lobbied so aggressively for her to be considered. But he also shared in the raising of their children. And she talks about how important that is in the book, and how that really made a difference in her ability to have the full life that she did.
There's a famous story that I know you know well of, I think when their son James was in, I can't remember the age, you might remember better, maybe middle school. And someone from the school called then Professor Ruth Bader Ginsburg in her office to say that there was some sort of discipline issue at school. And she got consecutive of these calls, sometimes at very inconvenient times for her own work and her teaching. And so ultimately she responded by saying, this child has 2 parents. And from here on, I'd appreciate it if you would alternate whether you're calling me or the other parent when issues like this arose. And of course, the result, which Justice Ginsburg surely predicted, again, thinking of the sort of on the ground reality of the rule, is that the calls dried up almost entirely because nobody wanted to call the father. But I think the fact of that, and that I'm sure Marty would have been completely on board in that strategy, as a hilarious and telling sort of illustration of a relationship that, as you say, was one for the ages. I know it's something that all of us as clerks felt so fortunate to witness, was this amazing marriage in operation.
I'm smiling because you had no way to know this, but we had planned to talk about that story in our conversation, and then it would be in the book. And in the interest of time, I had to skip that. And when we were walking off the stage, she said to me, the thing was, James apparently was playing in the school elevator, and that's why he kept getting in trouble. And she leaned over to me and she said, this was wonderful, but gosh darn it, you never asked me so that I could tell the elevator story. That's my favorite story. And so I'm so glad that you brought it up here, because I've been carrying around guilt for like 2 years for not setting her up to tell that story on that day.
I swear to God, Amanda and I didn't set that one up just now, but I'm glad we had the chance to do it. We've got less than 10 minutes left, so I'm going to look into the Q&A here, and if folks want to send questions, we'll be happy to take some of them up. One is, tell us a bit about the origin of the title of the book. I think that connects importantly to the justice.
Absolutely. So there are 2 parts to the book. The first part is Justice, Justice, Thou Shalt Pursue, which is, of course, a passage from Deuteronomy. And when I clerked for her, she had that up on the Chambers wall in a piece of art. It was a really important sort of calling to her to pursue justice. I think that's what defined her as a person and defined her life's work. And so it's just it's a beautiful connection of this passage that was on Chambers' wall. She's a justice. There are a couple of references in the book to how Herma Hill Kay, who we were talking about earlier, testified at her confirmation proceedings, the justices that is, that in Ruth Bader Ginsburg, the president has nominated a justice worthy of the title. And so it all comes together. And then the rest of the title is a life's work fighting for a more perfect union. And that's another theme that's dominant throughout the book. She's constantly talking in testimony and opinions and speeches about how the Constitution calls on all of us to work to build a more perfect union. And that work is ongoing. And so that too is a major theme of her life and of the book. And so when you put them together, that's how we get to the title.
It's perfect. It's perfect. Both pieces. And the latter, you know, is an encapsulation of why it is the justice did not think that a deep and unshakable commitment to the Constitution meant having to think that the constitutional answers of the late 18th century needed to be the constitutional answers of today, that the document itself calls upon us and each succeeding generation to try and make our democracy more perfect, our union more perfect. And that was, I'm glad that that's an aspect of the title, because I agree with you, it's a through line of all of her work, not just as a justice, but earlier. You mentioned Herma Hill Kay again just now, and there's another question asking if you might say a little bit more about the companion book, the Kay book that you and the justice angled to make sure it came out alongside this one. Can you tell us?
This is a favorite topic, and if Justice Ginsburg were here, she would be so happy that we got this question. As I said, this book was so important to her. It was Kay's final work. She spent a number of years on this, pulling together the stories of the very first women law professors. And if I may, I have to say I'm very proud that the very first at an accredited law school was at Berkeley, and she was hired in 1919. And that's the first story in the book. But it's the story of these women who paved the way and who did so under very difficult circumstances. And so this history is really important. It's important because, again, going back to what we've been saying about Justice Ginsburg, it shows how far we've come, even though we know we still have a long way to go. And the justice really, this is something that comes through in our book. She cared very deeply about honoring the women who came before her, who paved the way, whether it's Polly Murray being honored in the Reed v. Reed brief, or a shout out to Harriet Tubman in her congressional testimony at her confirmation proceedings, or here chronicling and preserving the stories of the first women law professors. This was all really important to her. And the book is beautiful because it really tells each of their stories. The introduction is written by Ginsburg, and she tells the story of Herma, which Herma omits. Herma takes the story right up until she becomes the 15th woman law professor at an accredited law school. But another really special part of the book I really want to emphasize is the afterword by Professor Melissa Murray, because Herma had great intentions in doing this book, but by limiting her coverage to professors at accredited law schools, she missed some professors. She missed professors who were at schools that were not accredited. And there is a dark history to the accreditation process that excludes law schools that primarily consisted of faculty of color. And so Melissa's afterword, written with deep affection and love for Herma, who was one of Melissa's big mentors at Berkeley Law, also says, let's step back and let's look at the stories of some of the other women who also paved the way. And so it's a really beautiful compliment to the book. And I'm so pleased that it's part of the final product.
Terrific. It is a great thing that the two books are coming out in the same spring. I know the Justice will be very pleased with that. Well, Amanda, thank you so much for being with us this evening. Thank you again for writing this book. And thank you for continuing to carry the Justice's work forward. You know, all of us in this extended family that is the RBG clerk family have been looking to one another a lot in this past year, I know, for support. And I want to thank you for what you've done for that community of all of us as well. The Justice, we all know, was tremendously proud of you and your work and would certainly be, continue to be as you carry forward her legacy. So thank you for that.
Well, thank you. And as you know, she was profoundly fond of you and proud of you. And I'm very proud to be a part of the law clerk family with you, Trevor.
Me too. Thanks. And thanks to all of you for joining us, for being here this evening. It's been a great session. Thanks to Melissa and Abby and Claire at the Birnbaum Women's Leadership Network for the terrific work that you all do. There will undoubtedly be more programming from the BWLN coming soon, and we look forward to seeing you there for that. Thanks all. Amanda, good night.
Good night. Thank you for having me.
Thank you.
Thank you to both of you, to Professor Tyler and to Dean Morrison for this wonderful conversation. Thank you again to our co-sponsors, the NYU Office of Global Inclusion, Diversity, and Strategic Innovation, and the John Bradamus Center. And as Dean Morrison said, thank you to all of you for joining us. We hope you'll join the Birnbaum Women's Leadership Network for our upcoming events, which we'll put up a slide shortly. And you can join our mailing list, which the link is in the chat if you would like to join us for future events. So thank you again and have a wonderful evening.